Hello, everyone. Thank you so much for tuning in to Constitutional Accountability Center's 11th annual Home Stretch at the Supreme Court event, where we look at the cases that have already been decided this term and look forward to the cases that are coming down the pike. I'm Elizabeth Wydra, CAC's president, and I'm so thrilled that you're here with us. We have a stellar panel of experts with us today and a ton of important cases to discuss, and I'm looking forward to it, as I know you are as well. So in the early days of CAC, and I've been here since our founding in 2008, we used to tease our founding president, Doug Kendall, who created this homestretch event, for his penchant for using the word momentous. We would say, Doug, you've got to try to only use momentous once per document. That's the new rule. But I would be hard pressed to follow that same rule when it comes to describing this Supreme Court term. It seems like half a dozen or more cases could be deemed truly momentous. Presidential immunity, presidential disqualification under the Insurrection Clause of the 14th Amendment, abortion access with respect to medication abortion, which has the potential for impact far beyond that case itself, abortion access in emergency situations in states with draconian post-Dobbs anti-abortion laws, the ability of the federal government and its agencies to function in the public interest, gun regulation, criminalization of poverty. It is truly a term full of extraordinary, massively important, and yes, momentous matters. These cases are not just momentous in terms of their essentially important substance, but in many cases, they are vitally and urgently of the moment. In the presidential immunity case, for example, it is not just a question of what the court decides, but when. A clear rebuke of Donald Trump's outrageous, sweeping claim of presidential immunity is what the text and history of the Constitution require. A swift ruling is what the reality of democracy requires. The court has, in cases past, issued decisions very quickly in cases where it was necessary, and it is necessary here. While many have just assumed that the presidential immunity opinion will come out at the end of June, when most of the other, momentous cases, rulings and cases are handed down, that late decision would represent an inexcusable slow walking of this pressing matter for the nation. So a correct but expeditious ruling is necessary. Given this presidential immunity case and the other massively important cases up this term, it's no surprise that Americans are watching the court closely. After the earth-shaking Dobbs ruling, when folks who hadn't been paying that close of attention to the court started to find out what a Trump Supreme Court really could do, the court and its rulings have been in a spotlight. And it's not been particularly flattering. For years, the Supreme Court enjoyed a relatively high favorability rate, with a strong majority of Americans having trust in the court. But that trust has plunged. In an attempt to help the court rise above this crisis of legitimacy, the court announced toward the end of 2003, a code of ethics for itself. Something many of us, including myself and those of us at CAC, have been calling for. While it was a start, unfortunately, this code was not binding. It didn't have any real enforcement mechanism, and it has been basically something of a disappointment in its inaugural term. This is a deeply unfortunate state of affairs because America deserves equal justice under the law. America deserves a fair judiciary with both the appearance and reality of impartiality. But even a binding code of ethics likely wouldn't help this court fully escape the questions that many Americans have about whether this is a court that follows the text and history of the law where it leads, or whether it follows an ideological or partisan agenda. As I've said before, you don't need to be a constitutional scholar or Supreme Court expert to get that a vision of equality and liberty that does not include the right to choose for oneself whether to terminate a pregnancy cannot be genuine freedom. I really think that the free fall of faith in the court reflects that the American people get that some sort of irreducible minimum of liberty must be protected by the Constitution if equality and liberty are to have any meaning. And the court's overturning of Roe caused massive questioning of the court's commitment to fundamental constitutional principles. Fortunately, we have an all-star panel today to help us unpack all of this and more. I am so grateful that we are joined today by Easha Anand, Assistant Professor of Law and Co-Director of the Stanford Law School Supreme Court Litigation Clinic, Khiara Bridges, Professor of Law at UC Berkeley School of Law, Kelsi Brown Corkran, Supreme Court Director at the Institute for Constitutional Advocacy and Protection and Senior Lecturer at Georgetown University Law Center, Deepak Gupta, Founding Principal of Gupta Wessler LLP and Lecturer at Harvard Law School, and last but not least, CAC's own brilliant Chief Counsel, Brianne Gorod. Our conversation will be moderated by the always fabulous Mark Joseph Stern, Senior Writer covering courts and the law for Slate Magazine. Thank you so much for being with us today, and thanks to those of you watching. Mark, over to you.
Thank you, Elizabeth, and thank you to everyone who's watching. I'm so excited for this momentous panel. I think this is going to be a really great discussion of some cases that will soon be coming down the pipeline. And I just want to give everybody a heads up of how this day will go. So first, we're going to go over the cases in a sort of thematic order. So we're going to begin with the court and 2024, which is about the court's participation, interference in matters pertaining to the 2024 election, most obviously involving Donald Trump, but also two issues that will be very important to voters in 24, which are abortion and guns. We will then turn to the court and economics, where we will talk about some of the blockbuster administrative law cases, as well as the case about criminalizing poverty and homelessness that Elizabeth mentioned. And then finally, for our last third, we're going to open it up a little bit to talk about originalism and textualism and how the court is applying or misapplying these methodologies. Since this is CAC, of course, we have to talk about all of the ways that the justices may not be applying originalism in a way that accurately reflects history and fact. After that, we will open it up to questions. We will have about 15 minutes of question time beginning at 2 p.m. And I'm going to tell you how to submit your questions. First and most obviously, you can submit them through YouTube. Just make sure you are signed into your YouTube account and you can post a question. But if that's not feasible for you, you can also send an email to Temi at this email address, TONAYEMI at rabengroup.com. That's RABENGROUP.com. Just put CAC homestretch in the subject line and fire off your question, and we will do our very best to get to it. And the usual disclaimers apply: question, not a comment, and please try to keep it short. So with all of that out of the way, we're just going to go ahead and dive in. And as promised, we're going to talk about the really juicy stuff with our fabulous panelists now populating the screen. Such a pleasure to see all of you. And we're going to start with the court in 2024. We're going to start with the two cases that have Trump in the title. And that is the insurrection clause case, which has already been decided, Trump v. Anderson, and the absolute presidential immunity case, Trump versus United States. Brianne, do you want to take it away for us?
Sure, happy to. I think what is particularly striking this year, this election year, as we think about the court and 2024, is the extent to which the court is not just deciding hugely consequential, hugely contentious issues, which it's also doing, and I know we're going to talk about, but the extent to which it has been asked to decide cases that have the potential to have very direct implications for one of the major candidates in the election. First, of course, as you mentioned, the court was asked to decide whether former President Trump could even appear on the ballot, or whether instead he was ineligible because he is disqualified under Section 3 of the 14th Amendment by virtue of his involvement in January 6th. The 14th Amendment and Section 3, of course, were ratified in the wake of the Civil War to ensure that those who would engage in insurrection against the country would not be able to subsequently hold office in its government. The Supreme Court ultimately held that Trump could remain on the ballot because, in the court's view, congressional action is required to enforce Section 3 against federal office holders and candidates. Obviously, the court's decision to allow Trump to remain on the ballot is significant, but in terms of the opinion itself, it was almost more significant what the court didn't say than what it did. The court did not say that Trump didn't engage in insurrection. The court didn't say that Section 3 didn't apply to Trump. And the other thing that was really significant about the opinion was how quickly it came out, less than a month after the court heard argument in the case. And that's significant because it shows that the court can issue decisions quickly. And that is absolutely what it should do, as Elizabeth already mentioned, in the other Trump case, the Trump immunity case in which it heard argument last week. This is the case in which former President Trump is arguing that he cannot be criminally prosecuted for his actions in connection with January 6th because, in his view, former presidents are forever immune from criminal liability for actions they take while in office. This claim is completely at odds with the text and history of the Constitution. We filed an amicus brief in the case on behalf of an ideologically diverse group of scholars. And in that brief, we made the point, and Justice Sotomayor echoed this at argument, that the text of the Constitution provides no immunity for presidents. And there was a reason for that. As Justice Kagan pointed out, the framers were, in her words, reacting against a monarch who claimed to be above the law. And she asked, wasn't the whole point that the president was not a monarch and the president was not supposed to be of the law? Former President Trump's claim is not only at odds with the text and history of the Constitution, it's also incredibly dangerous, a point that Justice Jackson made at argument, expressing concern that if criminal liability is taken off the table, it would create a significant risk that future presidents would be emboldened to commit crimes with abandon while they're in office. Now, at the argument, there were a lot of questions about issues the court might need to reach if it rejects both Trump's broad immunity claim and the government's position that former presidents don't have absolute immunity from criminal charges related to their official acts. For example, how to distinguish official acts for which there might be immunity from private acts for which there's not. But what I think is really important to note is that it did not seem an argument like there were 5 votes for Trump's broad immunity claim. And as several justices emphasized, even Trump's own attorney conceded, the indictment against former President Trump involves allegations that involve actions that are completely unofficial. And so prosecution could occur expeditiously, no matter whether official acts are involved. And that's why it's critical the court issue a decision in this case quickly. It would be incredibly irresponsible if the court ultimately concluded that Trump can be subject to federal criminal prosecution, but delayed ruling in the case, such that the American people would be denied knowing the results of that prosecution before the election. So there's obviously a lot at stake here for Trump and for the election, but I think there's a lot at stake for the court as well and its reputation.
I guess I thank you so much, Brianne. I want to toss a question to the panel, which is basically, did anything that was asked by the justices at oral arguments surprise you? Were there any questions from the bench that caught you off guard or really made you raise your eyebrows? I did in a podcast with Pam Carlin last week where she said there were moments when she was shocked that certain words left a Supreme Court justice's mouth. And I'm just wondering if anybody wants to reflect on similar feelings.
Maybe I can say one thing that surprised me, which is not what came out of the justice's mouth, but what didn't. I thought it was notable that in a case about Trump's prosecution for leading an insurrection, the phrase January 6th was uttered exactly one time in 2 hours of argument. There's just sort of any time someone tried to bring up the facts of January 6th, several of the justices had a really strong reaction, like, no, don't worry about the facts of this case. We're writing an opinion for the ages, which is not usually how you think about Supreme Court cases working or any cases working. And I'm curious if my other panelists have thoughts about, is that strategic, right? Are the justices trying to get away from the facts of January 6th? Do they genuinely believe that this is the vehicle through which they have to lay out broad principles about presidential immunity or else? What's going on there? Because that to me was the most surprising thing about this argument.
I was struck by the same thing. I mean, there were several times where Michael Dreeben, who was representing the special counsel, seemed to want to try to bring us back to what this is really about and what happened on January 6th, and he was cut off. There were justices who said, I don't want to hear about the facts of this case. I'm interested in these broader questions. And there were statements that what we have to write is an opinion for the ages. And so it seemed like almost a willful attempt to prevent the real stakes of what happened on January 6th from entering the discussion in the courtroom. And, if the court's decision precludes a trial from taking place, from the special counsel's case from actually going to trial, that oral argument may be the last time that these events are aired in a courtroom where Donald Trump is the defendant. That would be really disappointing, I think, in terms of accountability for what occurred. I was also really struck and surprised by an exchange between Justice Barrett and counsel for President Trump. And I think she was almost conducting a kind of deposition where she extracted some really important concessions from President Trump's lawyers that some of the allegations in the special counsel's case indisputably involve personal conduct and could go forward. And so I think she's someone to really watch here. She seemed to understand that what we might need is a narrow opinion that says that, you know, some of what's at issue just couldn't potentially be immunized.
Yeah, I had a similar reaction to that exchange, and I was surprised because it seemed that Trump's lawyer was conceding much more than he had in the briefing, in the sense that he came in and said, yes, there are some private acts that can be prosecuted, and the key is to distinguish between the private acts and the official acts. It really, I think, laid bare that this is mostly about delay, right? The notion that this prosecution can go forward, and can they keep the clock running long enough that we make it through the election and the president can pardon himself or keep the prosecution from going forward.
Yeah, I was in the courtroom for this, and I didn't have a great view, but I could see Justice Barrett very clearly. And when she did that kind of deposition with John Sauer, the Trump attorney, she had this look on her face toward the end of the exchange, like, really? You're conceding all of this? And it was quite extraordinary because, as I think each of you has said in a different way, like, there's private conduct throughout this indictment that's alleged, and Sauer's argument ostensibly is that only official conduct is immune. And so it does seem, as Brianne pointed out, that the court should be able to send this back down fairly easily to the district court and say, of course the prosecution can move forward because there's so much private conduct. I'm not sure whether that will happen, but we'll come back to this case in the third part of our conversation. And right now we need to turn to the abortion cases on the docket. It's been, I guess, less than 2 years since the Supreme Court said it was getting itself out of the abortion business. And yet here we are with two major cases. And Khiara, would you like to summarize those for us?
Absolutely. So FDA versus Alliance for Hippocratic Medicine began when a group of anti-abortion physicians challenged FDA's approval of the drug mifepristone. So FDA approved the use of mifepristone as an abortifacient in the year 2000. And when the FDA approved Miffy 24 years ago, it approved the use of the medication up to the 7th week of pregnancy, and it required 3 in-person visits. On day 1, the physician would administer the mifepristone. On day 3, the physician would administer misoprostol, and then on day 14, the physician would ensure that all of the contents of the uterus have been expelled and that the abortion was complete. In 2016, the FDA approved a new protocol called a REMS for the use of Miffy and miso, and it eliminated 2 of the 3 in-person visit requirements, day 3 and day 14, and it approved the use of the medication up to the 10th week of pregnancy. And finally, in 2021, the FDA eliminated the last in-person visit requirement, the day 1 visit requirement, and this decision was reached because the in-person visit requirement had been suspended during the COVID-19 pandemic, and there had not been any significant increase in adverse events during that time. So before the case made it to the Supreme Court, the Fifth Circuit had ruled that the physician's challenge to the initial 2000 approval of the drug was untimely. However, it ruled in favor of the physician groups with respect to their challenges to the 2016 and 2021 changes to the REMS. And so the challengers are now asking the Supreme Court to affirm the Fifth Circuit's decision. And really what this case comes down to is whether judges are going to be allowed to second guess agency decisions. The FDA says that it went through the existing scientific literature and concluded that changing the REMS was safe. The Fifth Circuit, however, points to other studies that raise questions about the safety of the new REMS. And so the question really is, are we going to defer to FDA's decision-making, or are we going to let courts second guess it? So put another way, who do we trust to review the scientific data? Scientists at the FDA or judges? And another issue in the litigation, which we can talk about during the colloquy, is whether the physician groups even have standing to challenge the law. And then the other abortion case being heard this term is Moyle versus U.S. and Idaho versus U.S. And these cases raise the question of whether the Emergency Medical Treatment and Labor Act, or EMTALA, preempts state abortion restrictions and requires emergency room physicians to perform abortions that are illegal under state law. As a bit of background, Idaho has a law in the books called the Defense of Life Act, and it generally prohibits all abortions except those needed to terminate pregnancies that are the products of rape or incest, as well as those abortions that the doctor believes to be necessary to prevent the death of the pregnant person. Now, the government argues that this law and other similar state laws conflict with EMTALA. The government says that Idaho's Defense of Life Act criminalizes abortion in cases required by EMTALA, which requires emergency rooms to provide care that will stabilize a patient. The argument is that many pregnancy complications do not pose a threat to the patient's life when the patient arrives at the emergency room, but these complications pose a threat to the patient's health. And in order to stabilize a patient experiencing a pregnancy complication that threatens their health, providers need to perform an abortion. And just very quickly, consider a patient that has preeclampsia, which can result in the onset of seizures or brain injury. The patient won't die if they have preeclampsia, at least not immediately. So a physician is prohibited under state law from performing an abortion on a patient with preeclampsia, but the patient with preeclampsia will suffer harm to their health without an abortion, namely seizures and brain injury. And really what this case comes down to is whether the court will engage in a tortured reading of EMTALA to allow Idaho to force pregnant folks to suffer, all in the name of protecting fetal life.
So, Khiara, can I just ask, what did you think of oral arguments in the EMTALA case? It seemed to me there was kind of a gender breakdown with the 4 women against the 5 men in terms of, at a minimum, how seriously they treated the subject matter and the prospect of women dying from pregnancy-related emergencies, which we know is a real problem in the United States. On the one hand, you had Justice Barrett really pressing the attorney for Idaho saying, why won't you just allow these women to get abortions in these circumstances? On the other hand, you had Justice Alito basically saying, well, what if the organ damage is only temporary? Does that really require an abortion? I'm curious if you had a similar read.
Yeah, no, I got to say, I thoroughly enjoyed listening to the oral arguments because Kagan, Sotomayor, and Jackson were on fire. They seemed like mad as hell and not going to take it anymore. And it was kind of nice. It was refreshing to see that sort of interest, right, in people's lives, be articulated. Justice Barrett expressed some concerns. I was also interested in the way, sort of tying to our earlier conversation about the Trump cases, how she was surprised that the attorney for Idaho was conceding, right, that people are suffering in Idaho. There was a question about whether these the instances that I just described, preeclampsia, whether those are actually threats to a patient's life or patient's health. And so Idaho was kind of trying to suggest that there was no conflict between Idaho law and EMTALA, but he eventually conceded that there was some conflict and that people do have to suffer as a result of Idaho's reading of EMTALA. And so she certainly expressed surprise. And the last thing I'll mention is that I do think there was, to some extent, a gender breakdown with Barrett siding with Kagan, Jackson, and Sotomayor to the extent of being surprised and dismayed by the possibility that Idaho is forcing folks to bleed out a little bit before they can get health care. But Kavanaugh did make that statement where he thought it was good to know that people were needing to be airlifted to Utah. It's good to know that, folks can't get health care in their states and that they have to be airlifted to another state to get basic health care.
Yeah, and I just have to cite the work of the great Lindsay Harrison, who wrote a piece with Dahlia Lithwick that we published that documented, and I think Justice Kagan actually cited this, that in the very few months that EMTALA has been sort of nullified in Idaho, 6 patients have been airlifted from a hospital in Idaho to Utah to receive emergency abortions that are unlawful in Idaho, as opposed to 1 the entire year before that. So the facts on the ground are sort of screaming and terrifying in this case. I just want to briefly ask before we move on if others have reaction to the oral argument, specifically in the EMTALA case, since it was just last week and is still so fresh.
I would just say, like, I want to mention the other woman who was in this conversation, which is Elizabeth Prelogar, the Solicitor General, who is a stunningly good oral advocate, but I thought was just really amazing. And she seemed to really kind of summon a moral force about what the stakes of the case were that had just a tinge of, I don't know if anger is the right word, but certainly moral indignation that seemed appropriate. And she is, after all, from Idaho. It's the former Miss Idaho. And I thought she did not allow any of the justices to make this an abstract case. She reminded them constantly of what the real impact on women would be.
And I'll just plug quickly another piece that was published in Slate by my colleague Miriam, actually, which talks about both of these cases and the extent to which they really give lie to the claim that the anti-abortion movement cares about women and women's health. That's a claim that you actually see repeated all the time. It's all over the briefs that were filed in the mifepristone litigation by the Alliance for Hippocratic Medicine. And they do this even as they invoke laws like the Comstock Act, the 1873 law that was passed as part of a sexual purity campaign and closely linked to a growing fear of women entering the workforce and abandoning their roles as wives and mothers. And even as they make arguments like we see in the EMTALA case, where they make clear how much suffering, how much damage they are willing to tolerate to pregnant women. So I thought that was just really striking.
Any final comments before we move on? And we'll come back to this one too in the last section. Okay, great. So let's turn now to Easha, who is going to talk about a much less fraught and disturbing subject matter, which is guns, and specifically two cases on the docket this term: guns and domestic violence, violence against women, and also the bump stock ban. Easha, you want to take it away? Sorry, I think she needs to be unmuted.
Is that better? So thanks so much, Mark, and thanks to my fellow panelists. So this year's gun cases are kind of a continuation of a theme we've already heard a little bit about from Khiara, of the Fifth Circuit kind of widening the Overton window, going so extreme that even the United States Supreme Court, no shrinking violet, has to kind of tack back. And to be clear, tacking back may still kind of move the needle significantly to the right, just not going as far to the right as perhaps the Fifth Circuit has. So let's start with the Rahimi case. In this case, Mr. Rahimi is subject to a protective order after he assaults his girlfriend. And that protective order says you can't have a gun. So after the Supreme Court's decision in Bruin, it's clear that to impose any kind of restrictions on firearms, you've got to point to some sort of historical regulatory analog. So Fifth Circuit says no such analog. Domestic violence restraining orders haven't historically resulted in restrictions on firearm use or possession. Perhaps no duh, since domestic violence restraining orders weren't exactly widespread at the time of the founding. The Supreme Court actually seems quite skeptical of the Fifth Circuit's opinion, though maybe we can talk about why that skepticism was qualified and cabined in various ways during our open discussion. One kind of theme to maybe tee up here for our listeners is, at what level of generality do we define the sort of historical analog we're looking for, right? Is it there's a historical tradition of taking guns from dangerous people, as the United States defending the law would say? Or is it, there's a historical tradition of taking guns away from folks of restraining orders, but not convictions for domestic violence, which is sort of the way that the federal defender arguing the case wanted to define it. And a lot of the rubber kind of meets the road here, not just for Second Amendment cases, but for the sort of general originalist methodology, right? When all of our constitutional rights depend on historical analogy, the question of at what level of generality you define that historical analogy has real implications across a whole host of constitutional protections. On the second case, this is a case called Cargill. 29 USC 5845 outlaws machine guns, which are defined as weapons that automatically fire more than one shot by a single function of the trigger. The question is whether bump stocks, so you know bump stocks from the massacre in Las Vegas. These are devices that modify semi-automatic weapons to allow them to fire hundreds of rounds per minute simply by pushing the gun forward. The question is that a machine gun within the definition of the statute? And the Bureau of Alcohol, Tobacco, Firearms, and Explosives passes a regulation changing the status quo, saying bump stocks do convert devices into machine guns, and so they're barred. So one theme I want to tee up with this case is sort of this case at oral argument seemed to me a little bit of a preview of what the device of Chevron, which Deepak's going to talk about in a few minutes, might mean. So technically, Chevron wouldn't be implicated here because of the way that ATF passed this guidance. But bigger picture, I really thought this oral argument exemplified why we sometimes want to defer to agency expertise. So I wasn't in the courtroom, but folks who were tell me that during the kind of full third of argument that was devoted to the justices trying to figure out how these things work, like, do you press forward and then also pull back? If you're pulling back, is it actually pulling back on the trigger, or is the recoil energy doing some sort of work? Brian Fletcher of the Solicitor General's office is like pointing them to YouTube videos that have slowed down images of someone firing a bump stock. And people who are in the courtroom tell me that, complete with hand gestures, finger guns, the justices are trying to figure out how this mechanism works. And it sort of seemed to me like a real advertisement for maybe someone who knows a little something about these machines should be the one to be interpreting the statute. And if that's the case with something like the bump stock, imagine these questions applied to, the intricacies of the chemistry of a particular pollutant, or the physics of how a turtle excluder device moves through water vis-a-vis aquatic drag vectors, or any number of other kind of technical questions that we allow agencies to take first bite at. So I'll pause there. This Cargill case is not, strictly speaking, a Second Amendment case, though, of course, the justice's concerns for the rights of gun owners are hovering over the entire argument. And would love to hear from other folks about their thoughts about either or both of these cases.
Before we move on, I wanted to ask a follow-up question, which was about arguments and a line of questioning, especially that Justice Gorsuch was pursuing. So I completely agree with you that there is seemingly a majority ready to uphold this particular federal statute against the facial challenge at issue here, right? So the Fifth Circuit said it's basically always unconstitutional. You can never constitutionally disarm people under restraining orders for domestic violence. I completely agree that the court is likely to reverse the Fifth Circuit and say that's not right. But Justice Gorsuch kept talking about as applied challenges, especially due process challenges to the way in which alleged abusers are disarmed. Is that something that caught your ear and something that might worry us?
Very much so. So, it was clear, not just Justice Gorsuch, but Justice Kavanaugh, Justice Barrett also put forward this idea that sort of like, maybe there's a long tradition of taking guns away from people who are, quote, dangerous, but they were really concerned about whether this process was sufficient to identify these dangerous people. And Elizabeth Prelogar, the Solicitor General, came in and sort of said, there's actually a tradition of totally civil adjudications being sufficient to take firearms, but that didn't seem to really do enough work for the justices. The other thing I'll flag is that whatever happens with this 922 G8 provision, the justices certainly seem to want to leave open the idea that other parts of the kind of taking firearms from dangerous people piece of the federal statutory infrastructure would remain good law. So Justice Barrett expressly mentioned a case where there's a pending cert petition about the felon in possession statute. It's a case called Range that has very sympathetic facts. The felony at issue was falsifying statements to receive food stamps. And she seemed to kind of expressly inject that into the conversation as though to say, let's really cabin what we say here. Two, as you know, not even saying there's no theory under which these 922 G8 orders might be unconstitutional, but let's make sure we're not touching any other part of the federal apparatus and saying anything else is good law.
Other panelists' reactions to arguments, especially in Rahimi.
Well, I'll just note, I feel like this concern about the potential defendants was really present in the bump stock case as well. It was kind of striking to hear the court's conservatives, who do not always have a deep concern for the rights of criminal defendants, really going on at length about fairness to bump stock owners. Justice Kavanaugh made this point, Justice Gorsuch's, Justice Alito did. You heard them talking, I think, much more about that than about either the victims of gun violence or about the text and history of the National Firearm Act, which you would think, given their professed ideological commitments, they would have wanted to understand.
Right. There's a surreal moment in argument where Justice Alito and Rahimi quotes from the Alameda County Public Defender's brief, right? And I think it is interesting to see how this is the first time the court has meaningfully dealt with gun control in the criminal arena, which is actually where a lot of gun control happens, as opposed to in the case of a pre-enforcement challenge, or a challenge to someone who's denied a license after an application. And I do think that the court is going to reverse the Fifth Circuit. One takeaway from that is that the court just thinks very differently about the kinds of folks who are subjected to federal criminal law than they do about the person they picture who applied for a license, in a suburb of New York.
Yeah, and I think we should just briefly spell that out for folks who are watching. In the major gun cases before this, in Heller, McDonald, and Bruin, the gun rights lobby chose its plaintiffs. They said these are sympathetic individuals who seem like they're responsible citizens and can be a good face for this challenge to a gun regulation. But after Bruin, the 2022 decision kind of opened up the floodgates to endless challenges to every gun control challenge on the books. What you started to see was public defenders really, I think, Easha, correct me if I'm wrong, sort of at the forefront of the attack on state and federal gun laws, because of course you have an obligation as a public defender to make the best arguments for your client. And if every gun restriction is presumptively unconstitutional, of course you're going to make this claim in court.
I think that's exactly right. I think they had an obligation. And, in all fairness, I think that if the Supreme Court wants to have any kind of intellectual consistency, it surely has to think that the Pandora's box it opened when it comes to the Second Amendment, at the very least, means you can't put someone in prison for decades simply for having a gun.
Right before we move on, Khiara, I saw you starting to speak and then I cut you off. I'm sorry. Did you have something to add?
No, you didn't. You didn't cut me off. No, I was just reflecting on Rahimi. I think you guys have already covered the interesting parts of the oral arguments, but I just wanted to flag one of the interesting parts of the briefing, specifically by the public defender on behalf of Rahimi, is this, I won't call it a revisionist history, but it's engaging in telling a story about history that supports the argument that might not align with our understandings of history. And so what I'm specifically talking about, Easha was saying that the United States said, of course, there are no historical analogs to, stripping, people accused of domestic violence of their right to bear arms, because domestic violence wasn't considered a problem until, the 1970s, right? Women's rights movement. And there's this moment in the brief that's so fascinating to me where Rahimi's lawyer argues, actually, domestic violence was a problem. At the founding, they had big time issues with, husbands who they would run them out the street and they would do these horrible, quote unquote, lynchings of these folks who are accused of domestic violence. And so it's just so inconsistent with our understanding of societal, appreciation of domestic violence as a problem. So it's just sort of consistent with these revisionist histories, these selective renderings of history that allow the courts to reach the policy results that they want.
Right. Absolutely. Thank you. Okay. We're now moving on to the next part of this preview, which is the court and economics. We've actually already been talking a lot about administrative agencies, since that's a big issue in the Cargill case and in the Mifepristone case. But before we get there, we're going to talk about grants pass. And we really have the honor, I think, of being joined today by the individual who argued grants pass for the side that I personally call the good guys, which is Kelsi Brown Corkran of Georgetown Law. Kelsi, you want to take it away?
Sure. So thank you for having me. So this case arises out of the city of Grants Pass, Oregon. It's a city of about 38,000 people at the time of summary judgment. They have about 650 homeless people in the city, almost all of whom lived in Grants Pass for years before they became homeless, had jobs and homes, and then some sort of tragedy hit, most often illness, cancer, disability, and they ended up losing their homes and decided to stay in the community because either they had jobs there or that's where family was, and they were most likely to be able to get back on their feet. In 2013, the city decided that it needed to do something about this vagrancy problem. It was particularly acute in Grants Pass because they have no shelters in Grants Pass. They've got one transitional housing program that has compulsory religious activity and also doesn't accept people with disabilities, and it can only serve a small fraction of the homeless population. So there really wasn't anywhere for most of the homeless people in Grants Pass to go. So the city decided the way that it would deal with this was to aggressively enforce a set of ordinances that made it physically impossible for homeless people to stay in Grants Pass without access to shelter, without facing endless fines and punishment. So I won't get, you can listen to the argument if you want to understand how the language of the provision works, but essentially it says you cannot unlawfully camp in Grants Pass on public property at any time, but camping is not defined the way we think of camping. It essentially is defined as any place a homeless person is while covered with a blanket. So the ordinance uses the phrase for the purposes of maintaining a temporary place to live and attaches it to a blanket. So non-homeless people can, sleep in parks, stargaze, but any homeless person, as soon as they sit down, they have a blanket around them, they fall asleep, is going to be unlawfully camping. And so the question, if you listen to argument, is whether this is status-based punishment, which a case called Robinson v. California held was categorically cruel and unusual. Robinson involved a law in California that made it a crime to be addicted to drugs. So here the question is, if the ordinances here make it a crime to be homeless while sleeping. So if you add some sort of universal human attribute like sleeping, breathing, blinking to a status, does that make it not status-based punishment? Does that make it conduct-based, or does that fall within Robinson? So that was the issue you heard in argument last week. I can't overstate both how extreme the ordinances are and also how unambitious the claim is here. My co-counsel intentionally brought an incredibly narrow suit because they wanted to stay within Robinson. So it does not challenge the city's right to impose time, place, manner restrictions on when and where homeless people sleep. We did not seek to enjoin the piece of the law that bans tents. The injunction allows the clearing of encampments. It allows the sleeping ban to be enforced against homeless people who decline shelter. And all of the other laws involving littering or public urination or defecation or drug use or violent harassing behavior, really all of that is still subject to punishment. The only issue is whether the city can have a 24/7 citywide sleeping ban that forces its homeless residents to either leave the city or face endless time fines and jail time. And the intent was to have them leave the city. The city acknowledged in the litigation that they wanted to push all of the homeless people into federal land outside of the city. So there's a lot of, I was heartened over the course of the last few months while the case has been in the news a lot, that initially it was referred to as a camping case. I think by the time we got to the last week or two, people understood this case doesn't actually have anything to do with camping or tents, or a lot of what people on the West Coast are frustrated with. So we'll see what the court does. I think it's especially troubling here that if the city is allowed to have a set of laws that make it physically impossible for homeless people to stay in the city, what they're doing is pushing all of their homeless residents into other jurisdictions. And so if the court blesses that, we could be looking at a future where every jurisdiction just makes it unlawful to be homeless, and fines, jail time escalate. And we've got 652,000 homeless people in our country. We'll have nowhere to go.
Do any panelists want to reflect on how oral arguments went?
I'll just say that Kelsi was brilliant at oral argument. And for those who don't listen to oral arguments all the time, I think it's a really great argument to listen to, in part because it doesn't turn on, a lot of technical legal rules. A lot of it was about how does this really matter on the ground? And we're really talking about whether we're criminalizing people, who are just sleeping with a blanket at night and have nowhere else to go. And I thought Justice Kagan and Justice Sotomayor, particularly in striking ways, tried to make clear that those were the stakes. At one point, Justice Sotomayor asked, what are people supposed to do? Are they supposed to kill themselves? Like, how do you avoid getting prosecuted for this? And I do think while some of the justices frankly struck me as surprisingly callous about the stakes of this, I thought that Justice Barrett and Kavanaugh in particular appreciated and were concerned by the consequences here. But I think for some of the conservative justices, it's just an odd fit to fit this into the Eighth Amendment and have this be about punishment. And so perhaps they will say something about alternative theories like due process theories that could reach the result that Kelsi is seeking, even if she doesn't prevail despite her brilliant advocacy.
And I'll say, I mean, on the Eighth Amendment point, what the city of Grants Pass has been saying is that the Eighth Amendment bans only particular methods of kind of painful, kind of physical punishment like torture. And I think one thing that was heartening to see was that there didn't seem to be a lot of sympathy for that broad argument among the justices. It didn't seem to be making a lot of headway, which is a good thing, because I think that argument is completely at odds with the history of the Eighth Amendment. And this is something that the justices talked about, an argument point that we made in our brief in the case, that the Eighth Amendment incorporates this idea of proportionality, that the punishment needs to fit the crime and needs to be proportionate to the crime. And that's an idea that dates back to the Anglo-Saxon era in England. It was incorporated in the Magna Carta. It was borrowed wholesale from the 1689 English Declaration of Rights. Justice Sotomayor at one point in argument said to Grants Pass Counsel that you're asking us to ignore all of that history. And so hopefully here, when the court is considering how to deal with people who truly lack access to shelter, and obviously thus bear no culpability for being outside, with the blanket, the fact that there didn't seem to be sympathy for this broad argument, again, I found heartening.
Yeah, I was ready to talk at length about CEC's brilliant amicus brief if necessary, but it didn't come up. It's an interesting case because we do, I think, in many ways have originalism on our side. You can kind of look through the Howard Civil Rights Clinic had a terrific brief also that talked about how in the settlement system of the founding era, a law like this would have been an affront to ethics at the time and the way that folks thought about communities and their responsibility for taking care of their own. So this is one where we embraced originalism and history and tradition.
I'll just say two minor things besides echoing Deepak's assessment that Kelsi was terrific at argument. The first is Deepak noted that there were some justices who were perhaps less callous than you'd expect. There were also some justices who were a little more callous than you'd expect. At one point, the Chief Justice asked Kelsi, well, if you say that you can't criminalize being homeless, are we saying you can't criminalize being a bank robber? And just the idea that that there's any equivalency in your mind, that you thought that was a valid question to ask, I think portrays a real lack of empathy and understanding for the plight of folks who are put in this position in Grants Pass. And the second thing I'll say is I was a little surprised at how cavalier the justices were about this idea, like, what if there's a shelter in the next city or the next county or the next state over? But that's not the way we think about constitutional rights. In a Second Amendment case, we would never say, what if you could move to the next city and have a gun? In a First Amendment case, we'd never say, what if you could move to the next county over and open that bookstore? And so just the idea that for disfavored rights, and this is a callback to my mind to the pre-Dobbs abortion cases where Texas would make these arguments like, it's not a substantial burden on a woman's right to access reproductive choice because they can just go over the state line to New Mexico and get an abortion. It's just interesting to me to see the ways in which the justices for the constitutional rights they care less about, they're so sanguine about this prospect that maybe the next town over will allow you to do it. And as Kelsi noted, if nothing else from a sort of pure incentives and logic matter, that seems like a terrible rule to have, right? It just means the first mover can say, well, there's a homeless shelter in the next town over, and then the next town can say there's one in the next town over, and so on. But it's also a striking departure from how the Supreme Court has told us to think about constitutional rights across a broad range of settings.
That's a terrific point. And we could continue on this one for hours, but we only have minutes. So unfortunately, fortunately, we get to move on to Deepak. And we're going to be talking about the administrative law cases that come to the court as admin law cases, although there are, as I think we've sort of bitten into, these administrative law issues in the Mifepristone case, in the gun case. But Deepak, will you walk us through Loper, Bright, and Relentless, the so-called Chevron cases? Tell us what they're about. Tell us what happened. Give us a sense of what's going to happen.
Sure. At one level, these cases, you might wonder why we would be talking about these cases. They are challenges to a rule issued by the National Marine Fisheries Service that requires herring boats to bear the costs of having federal observers on fishing boats. And, we've been talking about abortion and guns and the Trump cases. And those don't sound like blockbuster cases. But these are really important cases about the deference that courts give to federal agencies' interpretations of the laws that they administer. And we've already been hearing that this is a cross-cutting theme across the cases. This is a Supreme Court that is suspicious of agencies and their expertise, and a court that really thinks that judges, and particularly them, these justices, should be in the role of deciding questions that have historically been decided by agencies. These are cases that affect consumer protection, workers' rights, financial regulation, anything where you have expert administrative agencies that are making decisions about how to fill gaps in the laws that are passed by Congress, because Congress, of course, can't foresee everything and doesn't have the capacity to address all the issues that might come up. And the fishermen in these two cases have explicitly asked the Supreme Court to overrule the Chevron versus Natural Resources Defense Council case from 1984. And you might wonder why there are two cases. It's because in one of them, Justice Ketanji Brown Jackson is recused. And so the court took a second case, the Relentless case, to ensure that there's a full complement of justices. This is something that happened in the affirmative action cases last term, where Justice Jackson was recused. And we're calling these the Chevron cases, as I mentioned, because there's a question about whether to overrule this precedent from 1984. The remarkable thing about this is a precedent from 4 decades ago that, when it was issued, was unanimous and was pretty uncontroversial. It was a case about an Environmental Protection Agency rule under the Clean Air Act. And the question was just, whether or not the courts would defer to the expert agency's interpretation of this phrase, stationary source, under the act. And actually, in that case, the environmental groups that were suing the EPA lost. And nobody thought at the time that this was a big blockbuster case, but it ended up becoming a kind of cornerstone in administrative law. It's in the lower courts, it's a precedent that's relied on every day, where there are complex questions about whether courts should defer at some level, when there's an ambiguity, to the expert understanding of administrative agencies. And the headline here, I think, and I'm curious what the other panelists think, is that after 3.5 hours of oral arguments, it's pretty clear that this Chevron rule, in anything like its current form, is not going to survive. The big question is whether the court will say that it's overruling the precedent, or place some limits on the precedent, as it has done before with other administrative law doctrines. Solicitor General Elizabeth Prelogar argued this, and she really emphasized how destabilizing it would be if the court were to overturn this precedent, and emphasized that the rule of stare decisis requires that challengers have a truly extraordinary justification to set aside a precedent of this kind, and hadn't done so. The liberal justices tried hard to emphasize the importance of expertise. Justice Kagan strikingly talked about a hypothetical involving Congress trying to regulate artificial intelligence. Congress can't foresee even a week into the future. And so you would need Congress, in order to regulate that area, to leave it to expert agencies to fill in gaps. But I think it was pretty clear that a majority of the conservative justices were not with Justice Kagan, Justice Jackson, and Justice Sotomayor. And so the only question is really, I think, how far they're going to go. And my prediction, just to lay it out there, is they won't say that they're overruling Chevron, but they will kind of acknowledge the reality that this court hasn't adhered to Chevron for quite a few years, and will place some restrictions on that. And I think this case, coupled with other cases that the court is hearing, will deliver a kind of 1-2 punch to the administrative state, where people will be able to kind of declare open season on regulations that have been on the books for decades, and that have been settled law. So I think it could be wildly destabilizing to the administrative state.
So, in theory, overturning Chevron affects regulation and deregulation equally. Any agency action, right, is going to be subject to the same level of review. There won't be deference. But do you think it's fair to say that either overruling or hollowing out Chevron will, in effect, put a thumb on the scale of deregulation?
Absolutely. There's no question that this is part of a deregulatory agenda that the court has. And it's no surprise that they're also considering cases, which Brianne is going to talk about next, about the Consumer Financial Protection Bureau, how administrative agencies make decisions, whether or not litigants can attack old regulations. So there's a deregulatory thrust to all of this.
Does anyone have any reflections on specifically Chevron arguments before we turn to the last case, which is the CFPB?
Yeah, I'll just add, because you mentioned a thumb on the scale. When I describe these cases to non-lawyers, what I emphasize is the extent to which they reflect just what we're expecting, a massive transfer of power from the executive branch to the judicial branch under Chevron. Inevitably, as Deepak was saying, someone's going to have to interpret statutes. It's just not possible for Congress to think through every scenario. And up until now, we've really deferred to the executive branch to do that. And so I think, when you ask this question about whether it's going to favor deregulation, yes, it's going to, because when you transfer the power to interpret statutes from the executive branch to a very conservative judiciary, that judiciary is right. That's the frame they're going to be looking at. It, I think, is what we expect. And you saw the same thing in prior terms with the major questions doctrine. All of this is about transferring power from the other branches to the judiciary.
I'll just add that how terrifying it is, to transfer power from experts in the agencies to the judiciary. As Easha was saying, in the gun cases, with the justices kind of like making like little fingers and trying to figure out how bump stock works. With regard to the Mifepristone case, one of the studies that the Fifth Circuit and the District Court in Texas relied on as sort of evidence that FDA did not do its job when it approved the changes to the rims was this study that was actually a blog post that was not peer reviewed that ultimately was taken down. And so because it wasn't good science. And so, a lot like removing power from agencies to review the existing literature and placing it in judges who, whether explicit or not, have sort of political leanings and partisan orientations is just a disaster in terms of regulation.
Perfect segue, I think, into the CFPB case. Brianne, if you want to give us the overview.
Yeah, well, Deepak said the attack on Chevron is just one prong in a multifaceted conservative attack on the ability of the federal government to function effectively. And this attack on the CFPB is another example of that same kind of structural constitutional attack being leveled against a federal agency that, if it were successful, would have major implications for the ability of the federal government to do its job on behalf of the American people. In this context, to protect America's consumers. So this is a case in which an association of payday lenders is challenging the constitutionality of the CFPB's funding structure because it is funded outside of the annual appropriations process. What the CFPB's opponents say is that this violates the appropriations clause, which permits Treasury payments only, quote, in consequence of appropriations made by law. We filed a brief in the case on behalf of scholars of constitutional law and history. And as we explained in our brief, this argument is completely at odds with both the text of the appropriations clause and its history. At the founding, as today, to appropriate money by law simply meant to designate a purpose for that money in a law that was passed under the normal process for enacting legislation. And that's exactly what we have here. The statute authorizing the CFPB's funding does exactly that. The appropriations clause, if you look at its text, it contains no other restrictions, no other procedural requirements. The history of the appropriations clause similarly provides no support for the CFPB's opponents. The appropriations power developed in England and later in America as a legislative check on executive power. It was never designed to be a judicial check on legislative power. And in fact, Congress has given federal agencies perpetual dedicated funding sources like the CFPB's since the founding. In fact, at oral argument, there was significant discussion of one of the historical examples that we discussed in our amicus brief, the Customs Service. At argument, Solicitor General Prelogger described this as the best example historically. This was the very first agency Congress created. It wielded extensive authority over a vital component of the economy and was financed not with annual appropriations, but with an indefinite revenue stream provided in the legislation creating it. All of the discussion of the history prompted Justice Kagan to say that the Bureau's challenges are, quote, flying in the face of 250 years of history. Fortunately, to the extent the justices' questions at argument provide any indication, there seemed to be real skepticism of the CFPB's opponent's claim that the Bureau's funding violates the Constitution. And this might be surprising to some, given the composition of the current court. This is a court, after all, that is markedly pro-big business. At CAC, we've been studying the Chamber of Commerce's success before the court for over a decade as a proxy for the success of big business, and the results have been striking. Since the Chief Justice and Justice Alito joined the court, the Chamber's position has won in roughly 70% of cases, a markedly higher percentage than either during the Berger or Rehnquist courts. And yet, notwithstanding this, I do think it's entirely possible that the Chamber's position in this case, which is obviously lined up with anti-CFPB, those who are opposed to the CFPB, that position will lose here. And if it does, I think it will be at least in part because of the strength of the text history arguments in support of the CFPB. And so I think this case is important, not only because the implications could be huge for the CFPB and for America's consumers, but also because this case does provide a key example of how important arguments grounded in constitutional text history can be at the court right now.
Thank you so much. I think that's a perfect segue into our final segment before we go to a few questions, which is originalism and textualism at the court this term. You mentioned, Brianne, that this is not an originalist theory by any means, no matter how desperately the Fifth Circuit tried to dress it up in the guise of one. I was hoping I could just sort of go one by one and ask each of you how you think originalism, original public meaning, and textualism fared in the cases. And Easha, if I could start with you, feel free to either select one case you want to talk about, speak broadly. I mean, how did you think the court dealt with these ostensibly sort of authoritative and official methodologies across the cases this term?
So there's so much I could say about this, but maybe I'll just pick one topic, one case that we haven't talked about to just tee up for the group. It's kind of an under the radar case called Pulsifer. It's a case about the First Step Act and sort of an arcane provision of it that limits eligibility for certain kinds of sentencing relief to folks who have, the statute is structured, who don't have A, B, and C. I don't need to kind of get into the details of it, but what I found striking about this case is that a purportedly textualist court takes that statute and an opinion written by, Justice Kagan, self-avowed textualist, right, famous coiner of the "we're all textualists now" phrase, sort of says, look, when there are two plausible interpretations of the statute, actually, we're not going to use our kind of tools of textualism to figure out which one's more plausible. We're then going to turn to kind of policy and purpose and our sense of what Congress was doing. Now, maybe that's a perfectly sensible way to interpret statutes, but it does reduce textualism to just kind of a gateway, right? You got to get something that's plausible enough. You got to find some dictionary somewhere to get through the door, and then it's all policy preferences all the way down. And we see this in a series of cases this term, many of them under the radar, where you have the justices sort of being satisfied that both sides are doing the textualist thing, cited some dictionaries in their brief, and then the argument is entirely about kind of the policy consequences, the purposes of the statute, and so on. I happen to think that it would be better for the court if they were more upfront, if that's sort of what their methodology is going to be, rather than sort of pretending like policy and purpose has no role to play in their, platonic ideal of textualism. But it's been interesting to see that peek out a little bit more over the course of this term.
Khiara?
Yeah, no, your question is a tough one because there is a large part of me that is irritated that we even have to engage with originalism. It's not a legitimate methodology of interpreting the Constitution, in my view. It was invented in the 1980s in order to justify the reversal of Warren Court decisions that, without actually saying that this was a politically, oriented justification for overturning these decisions. Instead, all we can say is, oh, we're invested in originalism. So, and I would just point listeners to Reva Siegel's work on this, Memory Games. It's in Texas Law Review. That being said, I'm still struck by the selective use of originalism. I'm still mad about Students for Fair Admissions versus Harvard. I'm still mad that the court professed its fidelity to originalism in Dobbs, and then completely ignored originalism in Students for Fair Admission versus Harvard just the next term, because of course an originalist interpretation of the 14th Amendment would necessarily lead to a holding that race-conscious efforts to bring people of color, Black people particularly, into the body politic was consistent with original public meaning of the 14th Amendment Equal Protection Clause. So, originalism really, causes me to get hives. That being said, I was really struck at how originalism has functioned in some of the briefings, specifically Rahimi. There's this argument that the United States makes that dangerous persons have always been stripped of their weapons. And it points to a number of different statutes and laws that strip dangerous persons of guns. And the response to that made by Rahimi's lawyers is that those were actually racist laws. Like those laws, dangerous persons were like, enslaved people and Mexicans and Catholics. And so there's this move by parties, inviting the Supreme Court to ignore some, evidence that folks were in fact stripped of weapons by leaning on the court's desire to position itself as like the racial justice court, the court that's actually invested in equality between the races. So it's really interesting to watch these moves being made and to observe whether the court actually takes the parties up on these offers.
Deepak?
So I sort of approach this question as an advocate, who has to function within the system. And I think it's always important as advocates to kind of distinguish between the reasons that might motivate someone to reach a decision and then the justifications that they later produce. Those are two different things for people just in life, but also for judges. And so I think, this is a court that it perceives itself as being, at least in part, an originalist or textualist court. And some of the justices have varying degrees of commitments to those methodologies. But, I think Easha mentioned this, that when you actually listen to the arguments, which is the justices, interacting with the advocates and trying to figure out how they want to decide the cases, you often don't hear as much about those commitments. What you often end up hearing is the justices just trying to figure out, how is this really going to work? What is the policy? How do you craft the rule? And maybe that's okay. I mean, if we are going to have a policy-making body with this kind of power, imagine yourself in that role. I think it probably would make sense to try to figure out what real-world impacts it's going to have, rather than asking what the meaning of a particular word is in the dictionary or what it was, at a distant point in time. So I think, whatever the justices say, the reality is that they're at least in part pragmatists. I think if originalism is going to be deployed as a tool, you would think it would be particularly deployed when you have a fresh constitutional question, when you have a new provision that hasn't been interpreted before and you don't have the weight of precedent, right? And so the Second Amendment was one such example. And so Heller is like the high water mark of originalism. Well, we had another moment like that this term, which was the Colorado case. There's virtually no jurisprudence interpreting Section 3 of the 14th Amendment to speak of. And so this could have been a moment to really think about, well, why did the framers of the 14th Amendment put this provision in there? Could it have been that, they just witnessed this insurrection, and it's like a really important protection for our democracy to not have insurrectionists, people who've taken an oath to defend the Constitution, running for office. And instead what we get is this, it's very hard to defend the Colorado case as constitutional law. It's just a very poor piece of work, and it makes very little pretense to be kind of trying to do that kind of historical work. To the extent there's any historical citation, I think it's just trying to make it look like Section 3 was about very extreme and very specific reactions to the Confederacy. And so, I think that tells you what the court really thinks of originalism in cases where it may matter. And then I'd like to think Brianne is right. I agree with her prediction about the CFPB case. I'd like to think that it's about the court being convinced of the original understanding of the appropriations clause, but I think it also might just be the practical stakes. If they hold that the CFPB is unconstitutional, it's very hard to distinguish that from the Federal Reserve Board's funding stream, which is basically the same mechanism. And so I think, it may be that there are good pragmatist reasons to reach that result, and then the opinion we'll see will ground it in history. But was that really the reason?
Kelsi?
Yeah, so maybe somewhat controversially, I'm not opposed to originalism as a tool for understanding or kind of thinking about constitutional rights in conjunction with precedent and text and kind of looking at everything holistically. What concerns me, Easha was getting at this a little bit, is how it can be a really thin reed to rely on, which strikes me, Brianne was talking earlier about the Eighth Amendment and this idea that the city pushed and grants passed, that it's limited to just really barbaric methods of punishment. And they made that argument based in part on a Scalia opinion in a case called Harmelin v. Michigan from a number of decades ago, where he very authoritatively, over the course of a number of pages, made the argument that obviously at the time of the founding, everyone thought that the Cruel and Unusual Punishments Clause was just about methods of punishment and not about the excessiveness of sentences in relation to the crime. Well, fast forward a number of years and legal scholars come in and they completely debunk Scalia's theory. He was relying on particular texts involving parliamentary debate over the Titus Oates incident after King James II, or the King's Bench had imposed these particular punishment. There's this, right? It sounds very authoritative when you're reading it, and then it turns out everything that Justice Scalia said was he just misunderstood what he was looking at. And so the idea that we can kind of just look at those sources and pull this scrap of paper out and make sense of it ends up leading to a lot of incoherence, which I think is what we're seeing after Bruin, right? We have these really authoritative positions about what it meant. We don't know how to apply that. And so again, I'm not worried about kind of looking and thinking about that in context with everything else, but it ends up feeling very much, as Easha said, like the dog is the policy preference and the tail is the originalism, and then you just kind of make the tail wag wherever you want, where you want it to go. And that doesn't seem like a very good way to be doing things. I would prefer that the court go back to really relying on precedent, which is just more concrete. You can have a body of jurisprudence to make decisions.
I'm shocked to hear that Justice Scalia would misread historical texts to reach his preferred policy outcome. Last but certainly not least on this question, Brianne?
Yeah, I think the story of originalism and textualism at the court right now is really a story of two courts, or maybe two sets of conservatives. Because you do have, no doubt, these cases where the conservatives seem totally disinterested in engaging with text and history. I think, as Deepak noted, the Section 3 case this term is a prime example of that. I think, as Khiara mentioned, I think the Dobbs case, I think the affirmative action cases in recent terms, these are cases where the problem is not with text and history. The problem is with the conservatives' failure to meaningfully engage with the text and history. Because if you look at the text and history of the Constitution, the text and history of the whole Constitution, it supports affirmative action. It supports access to reproductive rights. And so you have this category of cases where there is selective originalism on the part of some of the justices. And yet there are also definitely cases where I think focus on text and history, be it constitutional text and history or statutory text and history, produces decisions that, given the composition of the current court, are surprising and seem to be at odds with what we think are the ideological priors of the justices. Victories for workers, victories for consumers. We've already seen that this term, I think, in a number of cases. There have been already multiple cases this term that don't generate the sort of big headlines that the cases we've been focused on generate, but are nonetheless incredibly important. There's a case called Wydra, which involved the requirements to bring a claim under Title VII for employment discrimination. There, the court recognized that some courts of appeals were imposing requirements on individuals who had been victims of employment discrimination that had no basis in the text of the statute. There's a case called Kurtz in which the court held that individuals whose rights have been violated under the Fair Credit Reporting Act can hold the federal government accountable in court. There's a case that one of Deepak's partners argued, Bissonnette, in which the court held that certain workers could have their day in court instead of having to go into mandatory arbitration. So I really think there are cases in which text and history can move the court, even the court's conservative justices. And then there are the cases where they allow their ideological views to trump what text and history require. And in those cases, I think it's really important that those on the other side marshal the text and history of the Constitution and hold them accountable with a longer view of the law and justice and where they might eventually lead.
Thank you. I appreciate this broad spectrum of thoughts and hope that or wish that we had another hour to continue discussing them. Unfortunately, we have just a few minutes for just a handful of questions that I'm going to draw. And the first one is about the mifepristone case. And someone has asked, does anyone think the doctors in the mifepristone case have standing? And how could a ruling in their favor on standing impact the doctrine in general? And Kelsi, I think you wanted to handle this one first.
Yeah, that's certainly what struck me from the argument. And I guess this was clear in the briefing too, but just for folks who aren't familiar with the issue, you have a handful of doctors here who claim that the injury that allows them to get mifepristone enjoined is that in some scenario, a woman might take Miffy and then end up in their hospital, in their emergency room, and then the doctor will be required to do some sort of medical care that is against their religious beliefs. The chances, that just take all that as a given, the chances of this happening are just incredibly slim, right? That the stars would align in the way that that woman would end up in their emergency room. And as General Prelogger pointed out, there's already a conscious objection, right, that they each have. So they would never actually be required to provide care under those circumstances. And so you heard a lot of argument about this idea that is this injury that they're concerned about is really speculative. I think it was an exchange with Justice Jackson. Forgive me if I'm getting the justice wrong. I listened to it live. Where she kind of made the point. So this handful of doctors who have a one and who knows how many chance of ever having the circumstances come up have the right to get an injunction that keeps tens of millions of women across the country from having access to this drug is really an extraordinary standing theory. And I don't know if this was just because I found it so compelling and I was putting a kind of gloss in the argument. I would be surprised if the court holds that they have standing under these circumstances. Standing is really a double-edged sword, right? It's not ideological in itself. So to allow standing in these really speculative circumstances for these sorts of plaintiffs could lead to, a broader notion of standing for plaintiffs bringing progressive challenges as well. So I don't know if others think that. It was just I found it compelling, but I suspect that the case will be thrown out on that ground.
Yeah, I strongly agree with Kelsi. I'd be very surprised if the court were to conclude that they're standing here. And I think some of the conservative justices, you saw them, looking for other ways. Or I think, and they're certainly, not going to go as far as one of the judges on the Fifth Circuit who held that there would be like aesthetic injury. That's not even a theory that's being really pushed at the Supreme Court. So one concern I have, just for anyone who's watching who might be, a member of the press or people are thinking about how to talk about the result of the term, is that what you might see is a decision by the Supreme Court in this case, in the mifepristone case, holding that the challengers don't have standing. I think that's likely, and that will be interpreted as a victory for the government. And then a different result perhaps in the Emtala case. And there might be a tendency to think, well, the court sort of went both ways, and this is very measured and down the middle. But really, what we're seeing is that the theory of standing that was advanced here is so outside the norm of the law of standing, and it was only entertained because you have the Fifth Circuit really entertaining any kind of conservative challenge, no matter how extreme, and then the Supreme Court has to pare that back, and that's a theme that runs across the docket. So I hope that when the press kind of tells the story of the term to the average voter or reader, that message gets across.
Thank you. One final question, and I think I'm going to direct this to Khiara. I think it really ties up a lot of strands from this conversation. You touched on this earlier when you mentioned the lower courts relying on scientific studies that were then withdrawn. But so an individual has asked, how do the cases involving the power of federal agencies impact this case? And I'll just broaden that out a little. How does the court's general skepticism toward agencies affect this case? And how did it manifest during arguments? And I'm thinking not just about standing, but when some of the conservative justices did turn toward the merits question and the substantive question, it seemed like they perhaps don't have the most sophisticated grasp on how medication abortion operates. And I was hoping you could just sort of reflect on that, and also how it might be kind of a preview alongside Cargill, as Easha discussed, of what it looks like when non-expert judges are skeptically reviewing the work of agency experts.
Yeah, it doesn't look good. Like I gotta say, like when I myself was reading the briefing in the FDA versus AHM case, and I was reading the doctors or the physicians group sort of describing the science. And I was skeptical. Like I was skeptical that FDA had actually done its job, like that it had reviewed all the scientific literature, that it had correctly concluded that, changing the REMS in 2016 and 2021 was safe. Like they told a good story. And it wasn't until I got to the FDA's briefing that I realized that I saw all of the oversights, all of the misreadings of the literature, all of the and also specifically the fact that the argumentation that the Alliance for Hippocratic Medicine was making depended on not deferring to FDA's judgment. So all of that to say, when we don't defer to agencies, I think that lawyers will be able to tell a good story about, a good story justifying deregulation. And so that's like sort of the importance of deferring to agencies, because if they're doing their job, which I'm convinced FDA did, we should be able to trust their decision and the resulting protocols that led us to 2021 not having an in-person visit requirement. Yeah.
That is a fantastic point. And I want to thank you and the other panelists so much for this conversation, and just turn it over to Elizabeth Wydra one more time to close us out for the day.
Thank you so much, Mark, and thank you to our amazing panelists. That was a fascinating discussion. I want to encourage everyone, if you've been inspired to learn more about the Supreme Court or want to dig deeper into the weeds in any of these cases, go to CAC's website at www.theusconstitution.org. And please also follow us on Twitter at MyConstitution. Thank you again, and thank you for joining us to those of you at home.